Telecommunication Lawful Monitoring of Messages and Security Measures Rules 2024. The central government has notified the Telecommunications Lawful Monitoring of Messages and Security Measures Rules 2024. These rules will replace Rule 419A of Indian Telegraph Rules 1951. They authorize specific enforcement and security agencies to monitor and intercept phone messages under defined circumstances to address national security concerns while attempting to balance individual rights. Key provisions of Telecommunications Lawful Monitoring of Messages and Security Measures Rules 2024. Authority for issuing orders. At the central level, the Union Home Secretary is the primary authority empowered to issue orders and monitoring messages. In exceptional or urgent circumstances, officers of at least the rank of Joint Secretary in central government can issue such orders to ensure timely action. At the state level, the Secretary of the State Home Department is authorized to issue monitoring orders to address security challenges specific to their jurisdiction. Operational level authorization. For operational needs in remote areas and during critical activities, orders can be issued by at the central level the head of an authorized agency or another senior most officer responsible for security operations. At the state level, the senior most officer or at least inspector general rank to ensure accountability and reduce misuse. Globally, similar practices exist in countries like United States where Foreign Intelligence Surveillance Act FISA code approves wiretaps and surveillance orders, and in the UK under the Investigatory Powers Act, which empowers specific authorities while requiring judicial oversight. Submission to the competent authority. Orders must be presented to competent authority within 3 working days to ensure transparency and oversight. Orders must be confirmed within 7 working days. If confirmation is not received within this period, monitoring activities must cease and any collected data cannot be used, ensuring adherence to due process. Record destruction provisions. Monitoring agencies must destroy interception records every 6 months to minimize privacy concerns and ensure that data is not misused. Exceptions. Records may only be retained if required for ongoing functional needs or under specific court orders to support legal investigations or proceedings. This aligns with practices in countries like Germany, uh, where Federal Data Protection Act mandates strict timelines for data retention and deletion. About Indian Telegraph Rules 1951. Indian Telegraph Rules 1951 are regulations governing the establishment, maintenance, and operation of telecommunication services in India. These rules were framed under the Indian Telegraph Act 1885, which empowers the government to regulate telecommunication networks. Process for obtaining telecommunication licenses. Guidelines are provided for obtaining permissions and licenses for telegraph services, ensuring structured growth of the telecommunication sector. Rights and obligations of service providers. These rules define the roles and responsibilities of service providers, including ensuring user data security and compliance with government directives. Use of networks for government purposes. The government can regulate telecommunication networks for national security, public welfare, or emergency purposes. Lawful monitoring or oversight. Surveillance and interception are permitted under Rule 419A in the interest of national security and investigation, ensuring legal backing for such activities. Globally, these measures resonate with frameworks like European Union's GDPR, which mandates a balance between security needs and personal privacy. Concerns with new rules. Lack of accountability. The rules lack explicit provisions for penalizing agencies or individuals who misuse interception powers. In comparison, the UK Investigatory Power Tribunal provides a mechanism for individuals to seek redress if surveillance powers are abused. No accountability during 7-day confirmation period. The absence of accountability during the interim period raises concerns about potential misuse. Best practices such as requiring immediate reporting to an independent oversight body, as seen in Canada's Communication Security Establishment, could enhance transparency. The broad interpretation of an emergency situations could lead to unchecked interceptions. Introducing detailed guidelines or judicial approval mechanisms like those under the US Patriot Act can help prevent abuse. violation of privacy and personal liberties. Arbitrary implementation could infringe on individual freedoms and privacy rights. Countries like Sweden, under the Swedish Signals Intelligence Act, emphasize the necessity of proportionality and judicial oversight to protect personal liberties. The Telecommunications Lawful Monitoring of Messages and Security Measures Rules 2024 aim to address the dual objectives and of national security and operational efficiency. However, the lack of robust accountability mechanisms and safeguards against misuse highlight the need for comprehensive reforms. Adopting global best practices, ensuring judicial oversight, and maintaining transparency can strengthen public trust while upholding constitutional rights.